Receiving divorce papers can be a difficult and emotional experience. It's a formal notification that a significant chapter of your life is changing, and it marks the beginning of legal proceedings that will determine important aspects of your future. Understanding the process and knowing what to expect can help you navigate this challenging time with more confidence and clarity. Once you have been served, the first thing to do is to examine the documents carefully so you can accurately complete the response. Note that there will be very important information included in the papers you receive, such as the standard family law restraining orders. These orders become enforceable the moment you are served, and claiming ignorance of them will not work in court. Starting on the day you are served, you are required to file a response via Form FL 120 within 30 days. Submitting a response does not mean that you necessarily agree with the demands of your spouse. Instead, this formal reply to the divorce petition allows you the opportunity to confirm or dispute the details provided by your spouse. Even if you don't want to get a divorce, it is in your best interest to file a response so that your voice can be heard and your rights protected. California is what is commonly referred to as a no-fault state. This means that a divorce can proceed with the petition of just one spouse. So regardless of your agreement, the petitioner retains the exclusive right to pursue and finalize the divorce. Therefore, if you fail to respond within the 30-day timeframe, the petitioner may proceed with the divorce proceedings without your contributions or objections. If children are involved, even though the petitioning spouse should have already filed one, you will also need to fill out a declaration under the Uniform Child Custody Enforcement Act, which informs the court of the children's living arrangements over the past 5 years and any existing legal matters that might affect custody decisions. You will need to file your response at your local family courthouse. You can find yours online at courts.ca.gov. At the courthouse, you'll file the forms by giving the original and 2 copies to the clerk. The court will keep the original and return the copies to you. One is for you, the other for your spouse. You will also need to pay a filing fee. This fee varies between counties, but the standard fee is usually about $435. If you cannot afford the filing fee, you may be eligible for a fee waiver. To request a waiver, you would need to complete and file a request to waive court fees, as well as an order on court fee waiver. Then the court will review your financial situation to determine whether you qualify or not. Since the petitioner has initiated the case, you don't need a notice and acknowledgement of receipt, and therefore don't need to serve them in person. Serving them by mail is typically sufficient. However, even if you're serving your spouse by mail, you still have to follow strict rules on how to serve your spouse. The server must be over 18 and not involved in the divorce. They should mail a copy of your response and any other papers you filed, except any fee waivers, to the petitioner's lawyer if they have representation, or directly to the petitioner if not. Your server should take note of the date they mailed the papers, as it is needed to fill out the proof of service form. Once the papers have been served or mailed, have your server complete, sign, and date the proof of service form, ideally using the proof of service by mail form FL 335. After this, make a copy of the form and file both the original and the copy at the court where you filed your papers. The court will stamp the copy and return it to you. Keep this stamped copy for your records. Responding to divorce papers effectively is a critical step in the divorce process. By carefully reviewing the documents, filing a detailed and truthful response, and adhering to the required timelines, you can ensure that your interests are well represented in court. If you need a divorce attorney in Los Angeles or Orange County, California, don't wait. Call Jafari Law and Mediation Office to secure your consultation and take the first step towards a fresh start.